No, I've found my pens. I think these may be yours.
Yes. Yes, Mr. Camden.
Good afternoon, my lords. Before the short adjournment, under the heading of non-alternative, I've just shown you Young and Santander and it's on the Judge Gosnell's comments on the amount of effort being put in time in bundles in relation to a 140 HC claim. Keeping with that theme, could I ask you to go to bundle 4, tab 48, which is Johnson in the Court of Appeal, and ask you to go to page 1220, paragraph 16. What you'll see there, paragraph 16 extracted, is an observation by Her Honour Judge Sarah Richardson, who transferred the appeal in Hopecraft to the Court of Appeal. She observed that this is one that's become a very large number of cases brought in the County Court that raise the issue of what duty, if any, is owed where a commission is paid to a garage is arranged for its customer to finance agreement with the finance company. The number of cases is likely to increase given the publicity surrounding the possibility of making such claims, including on the high-profile money advice websites. The sheer volume of current cases is causing significant case management and trial management challenges within the County Court. My submission, obviously, is that's not a surprise, and if the alternative were to be followed, then that you'd see a lot more of that as well.
That's the four wins point.
So again, my lord?
That's the four wins point.
Yes, quite. But a bit of evidence in practice as to what happens.
Yeah.
Because what happens at the moment is that these defendants are committing considerable resources to defending these claims. Their efforts on this appeal are trying to stop, in my submission, these claims seeing the light of day. And the reason they don't want there to be an omnibus claim form with proper disclosure, careful analysis of the law, and proper representation and decision by a judge is because that would truly make it difficult for them to continue to divide and conquer around the courts, around the land, because there would be an authoritative decision across a broad range of cases, carefully put together, and they would find it very hard to say, oh, well, we're different. If the job of choosing and selecting test or lead cases is done properly, then they'll find that much more difficult, leading to settlement, one would assume. At the moment, for instance, they can look at Johnson and say, well, Johnson's not the same because that was a really high commission and a commercial tie. But they can always point to individual differences. The way you've got, say, 10 or 15 cases that are well chosen, you won't be able to do that. You will truly have a system where district judges and circuit judges can really say, well, you're really going to have to distinguish yourself from this, you can't. And of course, there'll be cost consequences against people that obviously go against that. So it really would be a valuable and important and worthwhile exercise in doing. Now, by following the policy that they have, which is what I've dubbed divide and conquer, they have had successes because they can, against unrepresented or poorly represented people, have some measure of success by creating the difficulties and the doubts that one can see. And indeed, they even proudly told the FCA of this in terms of their representations involving these schemes. So if you go to the additional unagreed bundle, which is the FCA thing, and go to the policy statement, which starts at page 10.
10?
10, and go to page 16 of that, which is paragraph 217. They say this is the firm's representations. They had experienced high success rates in the county courts, and there had been financial ombudsman decisions dismissing unfair relationship claims, meaning the proposed scheme would deliver outcomes that were inconsistent with litigation. So they're doing very nicely by the divide and conquer route and the equality of arms and all the other things. no proper disclosure in advance, disclosure 2 weeks before the hearing provided for by the CPR, etc., etc. And so it's not a surprise that they want that to continue, and that's why they're spending time and money defending this to the point of appealing it. So it's not about whether 7.3 is convenient or not. It's really about whether they want to face these claims at all. Because we saw in Abernethy, as I've said, that there's a good chance that a lot of them won't see the light of day if they can't be brought on a collective basis for reasons of efficiency.
Is there anything more to this submission than the words equality of arms?
Well, there's a bit more to it than that, but it bases itself around that principle, fairness, overriding objective. If we look at the way the judge dealt with this, if we go to his judgment at paragraph at page 462, Roman numeral 8, he deals with this. So we're now getting into the heading interest of justice. At 8, he says, in 1, the omnibus route would favour access to justice for those claims for small track and fast track claims. There's an imbalance of financial power between individual claims and defendants. Omnibus process would disadvantage the defendants on claim legal costs because by the separate route, would be on a small claims track, so they pay no claims legal costs. I assume they would send advocates and pay lawyers to defend each case and so would incur their own legal costs, but may save costs overall due to the increased prospects of settlement following cases once the cases are tried. USCMCs would be required by taking the omnibus route, but those that are held would cost more. Redress sums involved are likely to be small in some cases, but I have no evidence of how large or overall the range would be, and the redress may be more than just the DC paid. And then disclosure and other things mentioned. So, interest of justice and equality of arms, overriding objective, are very much an issue here. They are part of the balance, and are one of the reasons why it is convenient to have a 7.3 omnibus claim form. Now, I mentioned there the FCA scheme and its effect. You've seen we've prepared a note that's hopefully neutral and just tells you the contents. I'm not intending to go through that. That scheme came in force at the end of last month. It's not directly relevant to the review of Mr. Justice Ritchie's decision, because of course it wasn't before him, but it's a significant development since then in this field, so we thought it right to bring it to your attention. There are two significant points that we seek to get out of it for the purpose of this hearing. The first is, the FCA, having been investigating this problem since 2017, plainly consider there's a high degree of commonality between these claims. So much so, they've devised a common scheme to actually deal with all of them in terms of remedial scheme. But in those circumstances, and despite that commonality, to be said to be rather difficult for this court to then conclude, nonetheless, there was no convenience here within the meaning of 7.3, to the extent that Mr. Justice Ritchie was plainly wrong. So do you think?
Right, well, if that's the submission, then you'll have to show us what the FCA say about commonality, because that's another very politely put threat. So I need to...
It's a threat, my lord.
Well, it's a threat. You'd be saying it's difficult for us to conclude something because the FCA have concluded something else. So what bit of the scheme is it that says these cases all raise or all have a high degree of commonality?
Well, my lord, if you want the detail on this, I have to sit down and let my learned junior, who has produced that note, address you on that. He's
right. Well, it's just that may be a good idea, just so we have the references to where that expression or that conclusion is reached.
It's within the policy document itself, so it's in the PCS 26.3.
So the document we were just looking at?
Indeed.
Yeah.
Lord, I'll let my learned junior who produced that note address
that would be, if that's all right, Mr. Cameron. Yes. It's just that one point, Mr. Butters. What's the bit that we are being told any successful appeal would be run counter to?
Well, my lords, the starting point is the statutory power under which the redress scheme was enacted. That's section 404 of the Financial Services and Markets Act 2000. And you've got that at page 3 of the FCA bundle.
Yes.
And you'll see there, section 404, subsection 1. This section applies if, A, it appears to the FCA that there may have been a widespread or regular failure by relevant firms to comply with requirements applicable to the carrying on by them of any activity. B, it appears to it that, as a result, consumers have suffered or may suffer loss or damage, in respect of which, if they brought legal proceedings, a remedy or relief would be available in the proceedings. And C, it considers that it is desirable to make rules for the purpose of securing that redress is made to the consumers in respect of the failure, having regard to other ways in which consumers may obtain redress. So it was on that basis, an identification of widespread or regular failings, in respect of which consumers have suffered or may suffer loss, in respect of which a remedy would be available in proceedings. So we say that identifies a commonality, and then when we look to the detail of the scheme itself, the scheme applies to scheme cases. And subject to exceptions, a scheme case is essentially any case involving a credit agreement with commission between 2007 and 2024. Not all scheme cases will attract redress. The touchstone is inadequate disclosure of a relevant arrangement, and a relevant arrangement is one of 3 arrangements, and we set this out at paragraphs 9 to 10 and 13 to 16 of our note. 1, a DCA. 2, a high commission arrangement. That's where the total charge for credit is in excess of 39%, and the amount of credit commission is 10% of that. And finally, a commercial tie of the like identified in Johnson.
And that's from 1.20 on page 12.
That's right, my lord, exactly. And where there is inadequate disclosure of a relevant arrangement, there is a rebuttable presumption of an unfair relationship. And it can be rebutted in fairly narrow circumstances, and we can continue on page 12 of the FCA bundle. And we can look at point 1.2.1, the final bullet point.
Sorry, page?
That's page 12 of the FCA bundle, my lord.
Thank you.
The lender can prove it was fair not to disclose one of the arrangements above, or that the consumer did not suffer any loss. This includes if a tie wasn't operated in practice or no better deal was available. But as we set out in the note, those, by reference to the rules, those exceptions are very tightly drawn. And then in terms of the question of inadequate disclosure, the FCA has adopted a common objective approach. So inadequate disclosure is presumed unless information as to the core characteristics of the relevant arrangement is disclosed, i.e. that there is a DCA, that there is a high commission, that there is a commercial tie. And the objective test is whether the relevant information was presented in such a way it was likely to have drawn the attention of the average customer to whom it was directed.
Which paragraph's that?
That, my lord, I set it out at paragraphs 11 to 12 of the note in terms of the references to the rules.
Oh, right, so that's not in the section we're looking at under eligibility.
It's not.
I see. No, but you've given us the references.
I give you the references
Yeah,
in the
fine.
note at paragraphs 11 to 12 because there's the policy statement which was published on the 30th of March of this year, and the relevant rules came into force the next day.
Yeah.
There are two schemes, nothing turns on that for today's purpose. And then in terms of the FCA's assessment that the scheme covers widespread and regular failings for the purpose of section 404, I could ask your lordships perhaps to turn your attention to pages 25 to 33 of the policy statement. That's internal pages 17 to 25. And I'll just show you the heading. You can see there at page 17, widespread or regular failures. And in terms of the failures, the FCA identifies inadequate disclosure of those three relevant arrangements. Sets out the FCA's assessment that inadequate disclosure of those relevant arrangements would likely lead to a court finding an unfair relationship, thereby showing its own assessment that the conditions in section 404 1A and B are met. And then it goes on to talk about how widespread those failures are, and we've set out in our note the numbers involved, and you can see, of course, that those are very significant. The headline numbers are 32.9 million agreements in the period 2007 to 2024. The FCA identified 27.6 million commission-bearing credit agreements. The FCA's assessment is that of those 27.6 million, 12.1 million agreements would attract redress under the scheme. Leaving 15.5 million on my arithmetic, my lords, commission-bearing credit agreements that would not attract redress under the scheme. In circumstances where the FCA's analysis, and it's set out in a diagnostic report that was published alongside the policy statement, identified that only in a very small percentage of agreements was the amount of commission disclosed. No disclosure of the DCA nature of a commission where that applied.
So I'm just wind back a bit to paragraph 19 of your note. So just to understand this, there are 27.6 million had some commission, and of those, redress will be due in just under half.
Yes.
So just over half won't.
Yes.
And that's notwithstanding the rebuttable presumption arrangement.
My lord, I assume the FCA's numbers take into account the possibility that in some cases the presumption of unfairness will be rebutted. But there are two principal ways in which a commission-bearing agreement may not give rise to redress. Either first, because the agreement is not a scheme case in the first place, and that will be in certain fairly tightly drawn scenarios. The first being where there's already been a redress agreement or a court judgment, or where the FOS has considered the merits. Another being limitation. Another being high value credit agreements, i.e. covering high-value vehicles. And then we get to scheme cases that will not be due redress. And there are two principal routes there. First, where there's no relevant arrangement. So take a non-DCA case where the commission is 38% of the total charge for credit or less. Those agreements won't attract redress. In terms of all relevant arrangements where the commission is £150 or £120 or less, depending on which scheme you're looking at, then no redress will be due. So that would apply to DCA cases as well. So the overall assessment is in the numbers I've set out within the note, and you'll see by my broad brush calculation, you're probably only looking at about 0.6 million cases involving disclosure of the amount of commission. So you're looking at just shy of 15 million cases on the FCA's analysis, where either there's no disclosure of commission at all, or there is disclosure that commission may or would be paid, but no disclosure of amount or those core characteristics, i.e. DCA.
Yeah, thank you.
Unless I can assist you further, those are our observations on commonality within the FCA redress scheme.
Yeah, that's very helpful. Thank you very much. And before you sit down, I should also thank you very much. I imagine that, as my Lord Justice Stuart-Smith put it to me this morning, you may not have had as much sleep last night as you would have preferred, but thank you very much for doing the disclosure note and putting together the bundle.
I'm obliged.
Yes, thank you very much.
So, my Lord, back to me.
Yeah.
Those are our
I put away the scheme file.
Put away scheme file, my Lord, yes. On 7.3 then, in summary, we say that there are no good grounds for this court to say that Mr. Justice Ritchie went wrong within the meaning of those authorities. He gave a careful judgment that identified the relevant principles of which there is no complaint, where he identified the two broad common issues, which I've demonstrated still exist, are common and need determining, and he also identified a series of other issues that down the road may well be capable of being determined in lead or test cases, namely the question under 140 A to C and fairness. There is nothing in my submission in that judgment where he went wrong, and this court should be reluctant indeed to interfere with it. The prospect of yet further delay and trouble in proceedings that have already been troubled and delayed by waiting for appeals and waiting for other things to come on would be unfortunate. He's chosen a route which is a convenient route. Other people may think there are other convenient routes that they may say is better or different, but that isn't the test. As the divisional court said in Abbott, it just has to be one of the convenient ways. and it plainly is, and would be hugely beneficial to the disposal of these very many claims, and very many claims that may follow. People either don't join the scheme or fall outside it would also be hugely benefited. And for this court at this stage to say no, it's not convenient, is outside 7.3, would be highly regrettable, and in my submission a significant step backwards in terms of group litigation and the management in the modern world, overriding objective, and all those things that we've been developing would be a massive step backwards if we were to go back on this here and this appeal were to be lost on that basis. So, my Lord, unless there are any questions on the 7.3 matter, those are my submissions.
Yeah.
We then go to what I call the case management appeal.
Yeah.
On this, the ruling, if you go to core bundle 2, page 477, can see at paragraph 5, page 478, where the judge deals with consumer credit agreements, is I'm going to order those agreements the claimants do not have, so limited to those they don't have, not all of them, but the ones they don't have.
Did you say you're on page 478 of the core bundle?
Core bundle number 2, my lord, yes.
Is that a transcript of?
No, 478. This is the order and reasons, direction and costs.
The order and reasons is a separate document. The order and reasons, because I have that in my core. The order and reasons is at 483.
But that's an order amended under the slip rule, and there are further reasons there, my lord. There's 2 documents, to be clear.
Yeah, this 478
Yeah.
says at 477 it's an extempore judgment.
Exactly. That's where I'm starting, and I'm going to go to the later one. Just
Okay.
So
But it's all the same thing.
it is, yeah.
Okay.
So it's 478, heading consumer credit agreements, paragraph 5, brokerage agreements under paragraph 6, still on 478. So I'm going to order the brokerage agreements as we disclosed in a relatively short period of time. I think the fair way to do this is to be a spreadsheet by the defendants showing those brokerage agreements which are not discretionary. And you'll remember that's to put the claims at risk of costs in the event, because we're trying to weed out those that don't involve a discretionary payment. So that's the methodology he used for that. In 7, he says he's going to have a relatively tight time scale. In 8, he says there's any explanation for it not being be produced, then obviously won't look on delay with favour, but he'll listen to that. And then leaflets, these are the things termed initial disclosure documents provided by broker-dealer to claimants, which might have, I mean, the relevance of that, of course, is that's the kind of thing that may have some disclosure in it. You might explain to the customer something about commission. So that obviously needs to be looked at in terms of whether it's a complete non-disclosure case, which most of the DC cases appear to be by definition. But this was to cover the bases and make sure that the basic information that deals with disclosure and deals with the interest rate point, the brokerage point, are covered. And the reason for that, obviously, so that can aid the choosing of good lead or test cases. That's the thinking behind this. So on the same themes, we then go to the document my Lord Justice Coulson talks about, which is page 485, where you have the order for the whole hearing. In terms of, if you look at page 486, the appeal should be allowed, etc. And then we have 3.3, 3.2 and 3.1, the disclosure of the various consumer credit agreements, brokerage agreements at 3.3 and 3.4, and leaflets at 3.6 and 3.7. And to be clear, this is only disclosure of documents that they have. They don't have to go and get them. This is in their possession. And he orders to paragraph 4 at page 488 a generic defence to the generic particulars of claim. And then he sets out his reasons at page 489. He says the root of these claims is pleaded as a discretionary commission. The sooner the non-DC claims are weeded out, the better. The sooner the level of the discretionary commission in each DC case is disclosed, the better. The claims can be progressed or settled. Respondents fears a forthcoming for application by the appellants to amend or add in clauses of action are not consideration now. He looks forward to the Supreme Court in Johnson, and he refuses stay. So that's justifying the pleading. And then disclosure, paragraph 6 and following. Response accepted at the hearing to determine liability or quantum in the DC brokerage agreements would eventually need to be disclosed. So pausing there, there is a complaint about this, But if these were to go, even on the small claims track, individually, the brokerage agreements would need to be disclosed. So the very thing my own friends say should happen here is it all should go to the four winds. Well, in that situation, they'd still have to disclose the brokerage agreement.
Isn't the issue here whether all these documents have to be disclosed in circumstances where the aim, at least according to the latter part of Mr. Justice Ritchie's judgment, is for there to be lead cases?
Well, my Lord, yes, for this reason. And I think if you carry on with the reasons he says this, is that to get the best possible lead cases, you need to see the spread of the whole population. See what the whole population, particularly of the brokerage agreements are, your interest rates, what you're dealing with, whether they're single commissions or double commissions, as we saw in Clydesdale. The degree of difference, if it's in Clydesdale between 4% and 28%, what are the ranges? And then you look at them all and say, right, we've got those. Now, a fair pluck of 15 lead or test cases needs to cover, as I said earlier, both ends of the spectrum and the bit in the middle. You don't know what the spectrum is unless you look at it. So my learned friends have said on this application, well, you have a sample, let's just choose 50 or 100. But that isn't going to be intelligent sampling. And it may lead to skewing the result, and you end up having lead cases that don't fully represent the population of claims.
Typically what you do is you have 50% chosen by claimants and 50% chosen by defendants.
But you can do that. You can do that.
The defenders put in all their best cases, and you put in all your best cases, and they've got a spread.
That can happen. Sometimes I've been in cases where the judge will actually say, well, actually a more sensible view is, well, let's have some in the middle as well, because we're all got investing this time and money. And there's no point in me taking my best 10 cases to take them to court, because they might ought to be like Johnson.
Yeah. Can I just ask you, going back to disclosure, what do you say is involved in the giving of disclosure? You've got a claimant's name, an individual claimant's name. You've got a date of transaction. You've got a
agreement number,
and you've got the dealer identified. So obviously, Mr. Goodall may have a different view of this, but your view of it is that armed with that, BMW or whoever it may be all they have to do is to interrogate their records or go to the dealer to find out, if they haven't got it sitting in a nice file already, where the brokerage agreement is.
Yes, the consumer credit agreements that they don't have, any because they had some and some were missing. The brokerage agreements in particular, and any leaflets they have, which would be given to the customer to advertise, if you like, the product.
But the core document in your submissions is the brokerage agreement.
Correct.
Because
not least because if it isn't a DC agreement,
then they're outside this action.
You can get rid of them before more costs are incurred.
Correct.
Because the credit agreement and the leaflets are documents which the claimants may have.
In some cases, they might, Lord, yes.
And if they were given to the claimants, then the defenders won't have them. They might have others.
Well, yes.
And the Leicester Aldridge witness statement is the information that we've got from the defendant's side about what would be involved.
Indeed.
Thank
you. The ground of appeal on this, we can look at that.
Bundle
page 24.
Thank you.
Doesn't it start on 23?
23, my lord, yes, you're quite right. At the bottom there.
Yeah.
And the point I was going to pick up on this was Roman numeral 6 at the bottom, where they say why they have been criticised for failing to at least have a look for them themselves when the relevant claims were struck out by order of His Honour Judge Worster. Well, they weren't struck out by His Honour Judge Worster. What he said was they would have to be reissued on their own behalf, or they would be struck out. So if they were to be issued on their own behalf, then the brokerage agreements and all these other things would again be immediately pertinent. And the suggestion that in some way these large commercial organisations didn't, for their own internal purposes, have a look at the brokerage agreements and the credit agreements is difficult to countenance.
That goes back to the point this morning, doesn't it? Both sides are relying on what they were ordered to do and therefore what they were not ordered to do.
Lord, yes, what I'm
That's
pointing
a
at,
common theme in this case.
Lord, yes, what I'm pointing at here is they're wrong to say that the claims were struck out, therefore I don't need to do anything.
No,
yours is a different point, which is that substantial commercial organisations such as the defendants should, one would expect, to be sufficiently well organised that they can find their brokerage agreements.
Correct.
Simple.
Now, we've also put just for your notice, a respondent's notices on this, which is in Core Bundle 1, tab 9, page 159.
Yep.
So we seek to uphold the orders for additional grounds we set out at we go to page 160. We set out in detail, really, as to the reasons why the CCAs would be relevant and should be disclosed. And we say at the bottom of one, all of which information be relevant to fashioning the case management directions, particular directions for sampling. As to the brokerage agreements, we say that will be helpful for the weeding out, which is in everyone's interest. And Roman numeral 2 on page 161 enable identification not only of whether the brokerage agreement involved a DC arrangement, but also the type of arrangement and discretion to the interest rate afforded. And then 2, the leaflets, what disclosure, if any, was made. Then paragraph 4 deals with the service of the generic defence. So in terms of the way that this was dealt with, it's true that this wasn't the same approach that had been discussed before His Honour Judge Worster, but it was the order that the claimants sought in their skeleton, etc., before Miss Justice Ritchie at that hearing. It wasn't, if you like, visited upon these appellants at that hearing. And not least, you've seen some evidence from Miss Lloyd, for instance. So everyone knew there was going to be a debate, and there was a debate at the consequentials hearing about disclosure.
So the orders at 3 and 4 were the orders sought in front of Mr. Justice Ritchie.
Correct.
And so presumably there's a cross-reference to the skeletons or whatever that were before him.
My Lord, yes. I mean, the point I'm addressing here is any suggestion, this was, if you like, Mr. Justice Ritchie designed this at the hearing, and those representing, I wasn't doing it, respondents jumped on that bandwagon. This was all in advance. Everyone knew.
Yes, that's what I'm saying. So can I just have the cross-reference?
To which thing, my lord?
To where it's set out in the skeleton argument that was before Mr. Justice Ritchie.
I'm not sure the skeleton argument's in the bundle, is it? I'll be corrected. Can I find that reference, my lord?
Yes, please.
The starting point, of course, if we go to the judgment on this, is paragraph 93 of the judgment, where it indicates this is what he's minded to do. Look at paragraph 93, page 463 of the bundle. The need for consequentials here and determine costs and necessary directions, I think, at times 2.5. I have in mind ordering disclosure of all of the brokerage agreements, credit agreements, and accompanying leaflets, and the service of generic defence within 3 months. So everyone was on clear notice that was the intention. That was on the 4th of March, some weeks before the consequentials hearing on the 8th of April. So everyone had due notice. The reference to the skeleton, my lord, is Core Volume 2, page 837 at...
Core Volume 2, page 827.
So Volume 2, tab
67.
Tab 67, page 837. Sorry.
And that's your skeleton. Thank you.
Now, he'd obviously given considerable thought, the judge, to the way he was going to, this case was to continue managed as a 7.3 case, and to take it forward, because it had obviously reached an impasse. There'd been not a lot of progress for His Honour Judge Worster. You've seen the exchange of sampling proposals, some of which are just advocacy documents to say they shouldn't be sampling. I'll give you an example of that if it helps. But what this was going, and there was going to be, on any view, questionnaires. Now the questionnaires obviously are the claimant's side of things. The questionnaires will set out and agree questions which elicit more information from the claimants. What this disclosure was going to do was elicit more information from the defendants, in order you could see both sides of the picture, in order to assist in the case management and the decision as to what would be sensible lead cases. And without the brokers' agreements, and indeed without the consumer credit agreements, indeed the leaflets, so far as they are available, you really are going to have an incomplete picture. And without the brokers' agreements, it's very difficult to know how you would, standing back from it, decide what lead cases to have. How do you decide what the two ends are in the middle? We have no idea what the population of claims contains. So if you take that submission and look at it through the prism of some of the sampling proposals from the defendant, so I take one by way of example, supplemental bundle, tab 9, page 123. This is the sample of AB and MFNL. If you go to the top of page 123, and this indicates, this paragraph 18, what they say should be put in the questionnaire, including the top of page 123, if you see, credit agreement, and the lower interest rate that it is claimed that the claimant could have secured but for the DCA.
Sorry, where are you reading from?
Top of page 123.
123?
123, my lord, yes.
Yes, I've got that. Paragraph 18?
Yes, the top of page 123, carrying on paragraph 18 at the top.
Oh, yes.
Credit agreement and the lower interest rate is claimed the claimant could have secured but for the DCA. Now, just pausing there, that is going to be, like in Clydesdale, the lower end of the discretionary interest rate. You'll need the brokerage agreement to know that. So it's only a small example, but what it goes to show is you can't ask the claimant to set out their case, even in questionnaires on points like that. They don't have the brokerage agreement. So that then comes to the heading, the defendant's complaint.
But to be fair, that's the end of a paragraph which starts, instead of generic pleadings, it's of critical importance to the viability and progress of the sample approach that the claimants now provide proper details of the claims.
Yes.
And this is point 5 of 5.
Well, yes, but what I'm saying is that they're saying that this is information we need to just, if you like, a quasi-particular claim. What I'm saying is, to meet that, what they're asking for, we would need the brokerage agreement, because we would need to know the lowest interest rate on the range by seeing it.
Yeah, no, I understand that specific point.
I'll give us an example as to why the brokerage agreements are important and why it's important that we get them at this stage, so the questionnaires can be complied with in the way they want and that the judge can have a sense of what the range of cases is.
Can we just go back to 4 on the bottom of 122? I'm not quite sure I understand it. The steps that the defendant failed to take vis-a-vis the dealer's brokers. What's being talked about now? Because on the face of things, that's another thing that your clients wouldn't know about without disclosure.
Where are you reading velocity, my lord?
I'm looking at the bottom of page 122. The last 2 lines.
Yeah.
Starting with 3 in brackets.
Yeah.
No, sorry.
Starting 4.
I'm number 4.
The steps
the defendant failed to take vis-a-vis the dealers stroke brokers. If I understand that rightly, that is asking for details of what the defendant should have done in relation to their dealers or brokers.
Yes.
Am I missing something? I can't.
No, because I mean, they may have a contract that we've not seen that sets out how they should behave one to the other.
Okay.
And you'd expect that to be in the brokerage agreement as well. Lord, yes, you're right. That is another point. I hadn't spotted that. But these are examples.
It gives you 2 out of 5 rather than just 1 out of 5.
My Lord, yes, and that's always welcome. So trying to focus on what the defendant's complaints are. The first is that disclosure should only be ordered for lead cases or alternatively from a sample of claims. And I get that from paragraph 62 of the Black Horse, Close Brothers Skeleton, Bundle 1, tab 17, 304. My answer to that is that the investment of the running of lead cases is a big investment. All I've been talking about today and saying how great lead and test cases are completely dependent on choosing the right ones. You choose the wrong ones, and it's clear they're the wrong ones, then all that investment is wasted of the court time, claimant's time, the defendant's time, and everyone's money. Because you're just dealing with one small subset of the spectrum, but by mistake. That's why I say it's important in my submission to have the generic defence to understand the structure, the detail of the range, particularly of the brokerage agreements here, to make sure you are getting lead cases that are suitable for determining both the broad issues and the issues under section 140 A to C. So following that through, the structure of the competing positions at a high level set out by the generic pleadings. The basic documents are made available with the credit agreement broker and the leaflets. The cases of the claimants can then be set out in the questionnaires in lieu of particular claim.
Just pausing there. The questionnaires?
Lord, yes.
Where does that come from?
Well, that's the process.
Once you've got the documents, can't you plead out some claims?
But you can, but what was expected here, and what often happens, is that you have questionnaires in order to choose.
Well, I'm a conventional sort of chap.
Well, can I finish the point? Because I think I'm not disagreeing with you. The questionnaires are a stage, and you then choose the lead claimants, or normally the pleading pool. And the pleading pool plead out the claims. And from the pleading pool, having pleaded it out, you look at which of those are particularly suitable to be the lead claims.
So it's a 3-stage process. Questionnaires, then a pleading pool, then you choose the lead claimants.
Correct. And you'll choose some spares.
That's the superstructure that of which Judge Worster was so critical.
I think so, yes, my lord, yes. But it is one that you've seen in various cases I showed you today, where that's exactly what happened. For instance, in the BOS against other borrowers case. Exactly, if I took you through the paragraphs.
The Joanna Smith case,
exactly.
The cost budgeting case.
Yeah, but she was setting out what they'd done there. I think they're 32.
Yeah.
Got down to 60.
Yeah.
So this is all normal stuff. But to do it, you do need to have those basic.
Just hold on.
Yes, thank you very much, Mr. Campbell.
So that's, I think, deals with the first complaint that I apprehend I'm meeting. The second complaint is that 3 months was insufficient time to comply. I get it from paragraph 33 of the BMW Volkswagen Skeleton Core Bundle 1, tab 20, page 341. Now, firstly, this is surprising given the amount of time that's been going on and the representation of these corporate defendants. 3 caches of documents are central to the issues and are routinely provided in an individual case in the county court, and so it can be assumed the lenders already have a developed system of operational resources to undertake that task. And if they needed more time, then they could obviously ask for more time in the usual way. And as I've said, their grounds of appeal are wrong when they say they're excused for not looking for them, because the claims have been struck out when they had not.
They're hoping you're going to run into the buffers altogether, and
Correct.
then they'll have saved it. I'm being told I'm being unfair, but the hope is that it won't be necessary for them to do so, or won't be necessary to do so on so many cases.
Correct.
Anyway, as you say, Mr. Campbell, the fact that the 3 months may need longer is not a reason for appealing the actual order.
No. Exactly so. And so we say the judge was right to express his disappointment that they appeared to be approaching the issue of disclosure from ground zero. And if in fact you look at paragraph 8 of Core Bundle tab 20, you'll see some of the work that one of the defendants at least had obviously been doing that sort of undermines the position they had to start from ground zero. So this is tab 20 of the supplementary bundle.
Page.
And it's at page 333.
Thank you.
You're right. Can I just get the right reference for that? And Core Bundle, right? Yes, I did. I apologise. Yes, not supplementary bundle, Core Bundle. I'm obliged, my little friend. So Core Bundle tab 20. So Core Bundle 1, tab 20, 333. I'm obliged. So you see there, this was in the case of the BMW and Volkswagen defendants. You see at paragraph 8, they've already done a table and done some work as to the number of discretionary agreements or not. So they've plainly been looking at, and understandably, getting the brokerage agreements out. So that's what we say about disclosure. But it was a necessary investment at this stage to disclose those documents if they're in their possession, and because that's exactly the disclosure they'd have to give in any event, which is what the judge said, and he was right so to do. We then come to the question of the generic defence separately. That was ordered in order to have clarity as to what I call the structural issues, i.e. the common issues. So at this stage, the Section 56 the Credit Act agency point was pleaded and unanswered. No idea whether that was running or not. Really important point, structurally important to the claim. There was no answer to the 122 Conqueror point, and we didn't know their position on the disclosure rule point either. That we've been going through this morning was the subject of the Clydesdale decision, 3.5.3. So that's how it appeared before him. The claimants had that generic defence since January 2023. And so asking for them to put a defence in within a number of months of this hearing, in my submission, isn't in any way too much to ask, and is obviously sensible. Pleadings are not designed to be in ether on their own. They're meant to be replied to, whether they're generic or individual. And it's very odd indeed that this one wasn't, and I understand his Honour Judge Worster ordered it didn't have to be, but before Mr. Justice Ritchie, he's not bound by that. And he was case managing the case sometime afterwards, having made some observations on the common issues, which are different to his Honour Judge Ritchie's, different emphasis on lead cases, different understanding of their relevance. And so in that connection, for him to decide a defence was necessary in my submission, was proper and correct. And certainly, again, there's enough authorities from this court saying that it's not for this court to delve down and assess case management decisions. There's various authorities talking about this court respecting robust case management decisions by trial judges. It's the whole idea of case management. If this court's going to intervene and say, oh, I'm not sure about that, in cases where there might have been other ways of doing it, but there was a good reason to do what he did. There were valuable reasons, there are unimpeachable reasons. And whilst people might say, well, I might not have done that, I might have done it differently, we've yet to hear any of those, even from my learned friends. They say things like, well, it should be from a sample, but how do you choose a sample? It should be from half or something else. Well, it's meaningless, because the value of the operation is to test the population of claims. If you don't have disclosure that can properly test the claims, then it's not valid disclosure at all. So in Clydesdale, there are two commissions, a fixed and a varied. How often do one see that? Are there other different tweaks that one needs to be aware of? If you're planning, you need to know these things. And the only way you do that is by seeing the brokerage agreement, a relatively modest thing to ask for a corporate organisation to provide, which it must have electronically in its systems, one imagines, and which it will need to produce in any event, even on the small claims track. So in those circumstances, to criticise the case management orders made by this judge in my submission is simply fails to get any real traction.
Of course, Mr. Justice Ritchie wasn't case managing the case.
Well, he
was dealing with an appeal
true
from a case management decision.
correct?
But the case management in this case, at the moment, is at Birmingham County Court.
Lord, that's true.
And so certainly my practice, both at first instance and in this court, in those very rare instances where I have interfered with a case management decision, I have referred it back to the court who has to live with the case management.
I mean, that was a possibility. He could have done that. That's not the question for this court. The question for this court was whether he was plainly wrong, A, to do what he did, and then to make the decision that he did on that case management.
Yeah, well, that's your case. That's one of the restrictions that we've talked about before.
Lord, yes. But in my submission, it would be an odd Court of Appeal judgment that seeks to dissuade judges who have engaged in a 2-day hearing dealing with effectively case management. The convenient disposal requires you to look at how the case is to be managed and then hold back when it comes to giving directions to give effect to that. What's that? The next stage is going to be a CMC before the case management judge. And the view of Miss Justice Ritchie was, unless the case is moved on a bit by the disclosure of these brokerage agreements in particular, then you just have a wasted CMC, because if everyone would turn up, ask for these things, there'd be yet further delay.
Oh, no, you set out your views in a judgment to steer the judge below. But case management usually is a personal thing. I mean, sometimes it's split between judges, but
the point
it goes back to the point I made yesterday, that this was an appeal. When people talk about upholding robust case management, that's of the judge who is doing, both then and in the future, the case management. This is slightly different.
Well, I see that slight difference. But by the same token, what he was trying to do, and he says he's trying to do, was...
The judge was laudably trying to move a case on.
Exactly.
That, for various reasons, has gone in a complete circle.
Yes. And so he wanted, there was going to be, the next stage would be a HHJ before his Judge Worster. He wanted to make that as effective as possible, because otherwise everyone would turn up at that CMC and have the debate, and I'd say, well, where's the brokerage agreements?
Well, as I say, that depends.
And then there'd be a delay, they'd disclose them, and they'd need another CMC to deal with sampling and how and on it goes. So what he was trying to do, in my submission, laudably, was cut through that and give pretty modest directions about the disclosure of the main document that his analysis required to be disclosed.
Well, at least one of the defendants say that the costs of complying with the order is more than the value of the claims they face. So you say modest, they would say disproportionate.
More or less, I mean, I see that. That's one of the smaller claimants. I heard that.
What's the answer to that?
Well, the answer in litigation of this type is that that there's a degree of rough justice there, isn't it, in terms of facing claims of this type. But the difficulty is that their claims may well have a characteristic that's particularly important or different, that requires to be tested and be part of the pool. And that's where we got into, as Judge Worster suggesting, that only the top three, the largest three, be part of the pool. Do you remember his judgment? He says this in the directions he would have given had he have given permission to continue, with perhaps a stay of the rest. But those directions weren't given. It was indicating what he would have done. So there's no, my learned friends sometimes say, well, there's no appeal from that. Well, there didn't need to be. There were no directions given. What Mr. Justice Ritchie thought, he was helping in that process by providing the information that was absolutely necessary. There can't be any doubt that the brokerage agreements are necessary to move this case on from this stage to the next.
Yeah, and that point should have been made, if it's right, should have been made to Judge Worster. and rather than the submission being made that there was a simple premise that fairness could be dealt with in principle, it should have said, we need the brokerage agreements, then we can choose some lead cases.
Look, Malid, I don't want to go over the background, what happened before it was on Judge Worster, but it developed as it did.
I mean, that's where we are now in late April 2026. So rough justice, part of facing claims of this nature, and by that you mean multi-claimant claims.
Yes. Yeah, I mean, my learned junior reminds me, on the small claims track then, it's always going to be disproportionate. If these individuals, these small appellants, are faced with the alternative, which is a small claims track, they still have to find the agreements. Even under that track, as you know, I think it's 2 weeks before the trial, there has to be disclosure of these would include these kind of documents. They'd have to go and find them then. So it's only a question of timing and when, not a if in one situation and a not in another. So really, my lord, that the mischief doesn't arise from Mr. Justice Ritchie or 7.3. It arises from the costs they say they're going to need to retract their basic commercial documents.
Yeah.
So, my lords, unless there are any further points, they would be my questions.
Just give me a minute.
On an individual basis, they'd be assigned to a small track.
No, thank you very much, Mr. Camden. Yes.
Lord, I want to start, if I may, with the claimant's pleading, or rather lack of it, because in many senses that's at the heart of the debate before the court. My Lord, Lord Justice Coulson made the point yesterday that this is just a regular piece of litigation to which the usual rules apply, and we agree with that. As I said yesterday, these are not GLO proceedings and these are not representative actions. So the usual rules apply. As I said yesterday, the practice direction that applies to unfair relationship claims under the Consumer Credit Act requires that the POC is served alongside the claim form, and that did not happen here. And there
Because
nothing...
Judge Worster effectively said it didn't need to be.
No, and there's nothing in the practice direction that suggests that some different form of particulars is permitted, and it's difficult to see why that should be so. As my Lord...
Well, can any of these claimants plead a claim without seeing the brokerage agreement?
Yes, I'm going to come on to that in a moment, my Lord, if I may. Okay.
Well, that point is obviously one of the main issues
Yes.
that has arisen.
The usual rules apply, including CPR 16.4 subparagraph 1, which stipulates that the particulars must include, so mandatory, quotes, a concise statement of the facts on which the claimant relies. And one of the points that's worth highlighting is that the CPR generally do not refer to or permit generic particulars of claim. And in fact, the only exception is in the context of a GLO. And if we can look, please, at the GLO practice direction, which is in the White Book at page 585. In fact, it starts at page 581, but the bit I want to go to 585, paragraph 14.1, we see the management court may direct that the GLO claimants group particulars of claim, which set out the various claims of all the claimants on the group register at the time the particulars are filed. Such particulars of claim will usually contain 1. General allegations relating to all claims, and 2. A schedule containing entries relating to each individual claim, specifying which of the general allegations are relied on, and any specific facts relevant to the claimant. So that, even in the context of a GLO, requires not just, as it were, the generic plea, but the specific. So even in a GLO, you're not departing substantially from Rule 16.41 that you plead out the statement of facts on which you rely. Now, here, each of these claimants has pleaded out that there was a discretionary commission arrangement. So that, with respect, is a red herring. They pleaded that with a signed statement of truth. What they haven't pleaded out is any other fact on which they rely. In fact, no other facts. Nothing about the circumstances in which they purchased the car, nothing about the communications between the dealer and them.
So what have they provided? The non-disclosure? Sorry, the allegation that's, you said, supported by the
They've
state.
pleaded that, they've asserted an allegation
Yeah.
that each of their arrangements was the subject of a discretionary commission arrangement.
Yeah.
And that's with a signed statement of truth.
And that's in the generic particulars.
Yes. But what they haven't done is they've given neither the court nor my client anything at all about the dealings between the dealer and themselves, of which, of course, we have no visibility. For example, what leaflets did they see? These leaflets that Mr. Justice Ritchie suddenly decided were so important and they should be disclosed, none of them are pleaded. What do the leaflets say? What was the point of instruction on the leaflet that was so critical? You don't find any of that in Mr. Justice Ritchie's judgment. You don't find anything in the pleading at all about the communications. What was said? What did they want? What was the discussion? And even in a GLO, you would have had that. And the very approach the claimants have taken here to their pleading, we would respectfully say, rather serves to highlight why these proceedings are not suitable for CPR 7.3. A single set of particulars that had complied with the rules properly in relation to the hundreds or thousands of claimants to which the claim related, pleading out as required the facts on which each of them relied, would have been totally unwieldy and indeed the antithesis of convenient. Now, my learned friend yesterday afternoon...
And that is, isn't it a recognition of the force of that submission? They've gone for generic particulars with more to come.
But that's the fundamental problem, my lord. My lord, I think a few occasions today have said this is all standard stuff. This is far from standard, my lord. Standard stuff is where you have a pleading that sets out the generic allegations and all the individual material relied on, perhaps by way of schedules, and the parties identifying, or the claimants identifying very clearly, here is the commonality.
That's where you get to. That's obviously where you need to get to before you can resolve the issues.
And we are a world away from that here. They've never got anywhere close to that.
I agree. But that's not the point.
It is the point, my lord, because a lot of my learned friends' submissions come down to this inter roram suggestion that somehow I'm trying to bring down the whole group litigation structure. I'm trying to prevent any 140A being brought under a omnibus claim form. I'm doing nothing of the sort. I'm here dealing with this claim, the claim we're looking at in these particulars. I'm not doing anything of the sort to try and bring down the structure.
And there are two issues. One is whether it falls within 7.3. And secondly, if it does, where do we go from here? So,
and you can only...
you've made your submissions quite beautifully, if I may say so, yesterday about 7.3. and have them well in mind. And if we agree with you, then this appeal succeeds, and we still have to decide where to go from here.
Well, yes, but the problem is my learned friend wants to have it both ways. He turns up with no proper pleading at all. There's this total movable feast going on in relation to the common issues. I mean, even today now we've got a third hard edge issue not relied on by the judge. No respondent's notice. I mean, it is truly remarkable. I'm afraid to say it's all been made up on the hoof, and the whole thing is a series of interrogatory submissions, which I fear my Lord Justice Stuart-Smith may have bought into. That somehow we're trying to kill these claims. There's no evidence to support that. There is simply no evidence to support that.
You're doing your best to
So
defend
no
your
evidence.
client's interests.
Sorry, no evidence to support which?
Well, one of the points my own friend said he made was that what we're trying to do here is that we know that if these claims are severed, they won't be pursued.
Oh yeah, no. Well, you made that point yesterday.
But I mean, it's worse than that, because we've asked them, what are the funding arrangements here? And they won't tell us. There's no evidence. In fact, these claims are funded.
They never do.
Well, but they can't then make the submission that they won't be pursued, my lord. If they want to say...
Oh, no, the submission that if you have to produce 5,000 individual claims at an average value of £1,000 each, that's not viable. That doesn't need evidence.
But it does, my lord. It does, because it needs to show two things. One, that Baring's law wouldn't be prepared to act on those claims, and two, evidence that the claimants themselves wouldn't pursue those claims. There's no evidence of that to that effect. And we know, just look at what's going on out in the country. There are thousands and thousands and thousands of individuals pursuing those claims. So why are these claimants any different? Now, my learned friend yesterday started his submission with the contention that what sets these claims apart is that they each concerned a discretionary commission arrangement, a DCA, which he described as pernicious and something which had not been dealt with in the cases we looked at yesterday. That's page 200 of the transcript. Now that, I'm afraid, is simply wrong. Johnson was, in fact, a case where the underlying arrangement was a DCA. Now, if we can take that up, please.
Well, just give us the references.
Authorities, volume 4, tab 52, paragraph 43.
43?
43.
Page
1424. So, Authorities, volume 4, tab 52, page 1424, paragraph 43. So there was an underlying DCA, but and I accept this is perhaps what my learned friend is alluding to, Mr. Johnson was charged the minimum rate, and therefore there was no additional element of commission in that regard. But that point rather serves to highlight that you can't just say, okay, there's a DCA, it's pernicious. You've actually got to look at the underlying facts to work out, okay, what happened in that case? What rate actually was charged, and how does that fit with the range available to the dealer? But the second point, and this is in many senses the more important point, is that it's clear from the analysis of the Supreme Court in Johnson that their analysis applies as much to DCAs as to any other motor finance case. And I'm afraid, my lord, I will take you to the passage here, because I want you to look at it, if I may say so. It's
Okay.
Volume 4, tab 52, at page 1492.
Paragraph which?
Paragraph 319, 319. Now, these were the non-exhaustive points that had been identified by the Financial Conduct Authority as relevant to commissions paid in these contexts. And we did, I think, look at this yesterday, but I want to just bring out one particular point. So 319, and they say in the fourth line, the court agrees that the factors in this non-exhaustive list will normally be relevant. And then we see the various points listed out, the second of which is the nature of the commission. Because, for example, a discretion commission may create incentives to charge a high interest. So the Supreme Court are not saying if you're a DCA, you go straight to jail, don't pass go, in other words, you're unfair, they're saying, no, you're still within the usual mix of cases. It's just one of the factors going into the mix. What is the nature of the arrangement? So exactly the same process applies under the statutory cause of action in respect of a DCA. You're looking at everything in the round and balancing all the factors. Now, the other point I'd make is that, by reference to Johnson, is that my own friend, on a number of occasions, both yesterday afternoon and then again this morning, use this language of there being a serious conflict of interest between the dealer and the customer. And that itself, he labelled as egregious, it's part of the pernicious conduct, and therefore it, to use his language, poisons the well, I think was the way he put it. Now, in fact, that very submission itself is contrary to the Supreme Court decision on the common law and equitable aspects of the case, because the Supreme Court decided that the dealer owed no fiduciary duties to the customer. And if I can show you perhaps two short passages on that, paragraph 276 and 277.
Could you possibly give page numbers?
1482.
Thank you.
Where he says at, where they say at 276, we now examine whether those typical features of the transactions under review give rise to a fiduciary duty and therefore no conflict and profit duties, sufficient to give rise to liability for bribery, either at common law or in equity. In our judgment, they do not. The typical features of the transactions are incompatible with the recognition of any obligation of undivided or selfless loyalty by the dealer to the customer when sourcing and recommending a suitable credit package. The assumption by the dealer of the position of intermediary or broker between the customer and the lender is of itself neutral as to whether an obligation of undivided loyalty is being undertaken by the dealer. The position of intermediary is not, nor is it analogous with, that of a trustee, company, director, partner or agent, but the continuing status of the dealer as an arm's length party to a commercial negotiation, pursuing its own separate interests, is anything but neutral. It is irreconcilably hostile to the recognition of a fiduciary obligation owed to another party in that negotiation. No reasonable onlooker would think that by offering to find a suitable finance package to enable the customer to obtain the car, the dealer was thereby giving up, rather than continuing to pursue, its own commercial objective of securing a profitable sale of the car. Now, I would answer the rhetorical question, where is this supposed duty of conflict coming from in that situation? I mean, the Supreme Court has squarely held there is no fiduciary duty, there is no conflict rule that applies, and therefore the language my learned friend used is simply inapposite. And my learned friend yesterday afternoon at page 220 of the transcript, again, used this submission as a launch pad from which to say, if you've got a DCA, it's basically game over. Unless there's some extraordinary countervailing factor, it's going to be unfair. And that is an anathema to the approach that is mandated under Section 140A. I made my submissions yesterday afternoon, yesterday morning on that, at pages 129 to 131 of the transcript, none of which my learned friends addressed. Now, I want to say something, if I may, about what my learned friend said both yesterday and this afternoon about the FCA scheme. He dealt with this yesterday at page 205 of the transcript. I just want to, if I may, just look at that passage. If you have the transcript available. If not, I'll read it out.
We have the benefit of the live transcript.
Yes. Well, maybe
myself, I haven't had the...
I mean, the thrust, I'll give you the references. It's page 205, line 25, to page 206, line 14 yesterday. And then today, it was the point that was made this afternoon about commonality. Yeah. And basically, the point that my learned friend was making, and it's yet another inter-oram point, is to say, well, be very careful here, Court of Appeal, because the FCA have already decided all these cases are common. There's commonality across them. Now, that, with respect, is a wholly misguided submission. But before I explain why that's misguided, I should just flag, so that the Court of Appeal are aware, you might have seen in press reporting in recent days that at least one consumer group has indicated they intend to mount a legal challenge to the FCA redress scheme, and we don't yet know what other parties might mount challenges. So I suspect the Court may wish to tread with some care in circumstances where the scheme may in due course have to be carefully examined by a court and possibly an appellate court.
That's not interim.
That's not interim, no. I'm just telling you, just so you know. Background fact, my lord. Now, but the short point is...
I should say that we don't feel terrorised, but we certainly feel...
Landished.
Yes, thank you.
But the short point is you can't deduce anything from the approach that's been taken by the FCA, because the FCA's work is directed towards putting in place a redress scheme pursuant to the statutory power that they have, and necessarily the FCA can't opine on the law, whether that be in respect of section 140A or indeed CPR 7.3, but in putting in place a redress scheme, the FCA have to necessarily deploy a regulatory judgment as to where they're going to put the lines, basically. Where on the dartboard are they going to work out who gets what?
I'm just wondering which paragraph of self you're about to go to.
Well, I'm not actually, but I could do, but I'm not going to do that. But I'm going to actually take you instead to two other documents. The first is the consultation paper itself, which is in the supplementary bundle at tab 41.
I'm afraid to say I'm not doing tabs, so if you could always give the page number.
It's page 322. Now this is an extract from the consultation paper. This is what preceded the policy statement, which I'll come to in a moment. And we can see here at 4.43, they say, in Johnson, the Supreme Court confirmed that the test of unfairness under section 140A is highly fact sensitive and permits courts to take account of a very broad range of factors. However, this is the important bit, a consumer redress scheme under section 404 must have objective, common and identifiable criteria so that firms can assess very large volumes of cases consistently, quickly and at proportionate cost. Our approach does not aim to narrow or redefine the court's legal test. It's clear to us that the amount of commission and the nature of commission arrangements can be highly material factors in the assessment of the fairness of a relationship. We are therefore making a regulatory judgment supported by our diagnostic work and the case law about the circumstances in which a firm should consider that the inadequate disclosure of certain features is likely to lead to a finding of an unfair relationship. So they're making a regulatory judgment as to where to place the lines. They're not saying anything at all about these cases being common, or there being commonality across them, or there being somehow suitable for multi-party claims. And in fact, we'll see in a moment, they say something that's not consistent with that. So that's the consultation paper. The same point comes out of the recent policy statement, and that's in the unagreed bundle at page 17. You can see...
Can I take it that now that both sides have referred to the unagreed bundle, we don't need to worry about the nature and extent of any disagreement?
I think that's right, my lord.
Yeah. So page 17,
page 17
which we looked at with Mr. Butters.
Yes, but he didn't take you to the bit that I want to highlight, which is the same language as we saw in the consultation paper, where they say, however, as we explained in CP 2527, that's what we just looked at, a consumer redress scheme under section 404 must have objective, common and identifiable criteria, so firms can assess very large. So they're doing something quite different here. They're just working out where they can draw some clean lines based upon their regulatory judgment only. Now, there's just two other points I want to just pick up from this document, but one of which I can show you, one of which I can't, because the extract's not in the bundle, but I'll tell you what it says. That the first point is on page 42, where in the context...
I see that in passing, at the top of page 18, they're obviously girding their loins for any challenge, because they say they rejected the suggestion that their approach was overly simplistic.
Yes. I mean, you don't need more to tell you. There's been a lot of speculation in the press about whether there's going to be a challenge, who is going to challenge it. As I said, what one consumer group's come out to say they're challenging it. We don't know what's going to happen.
On the face of it, I would have thought simplistic and broad was of general assistance to the consumer. But anyway. So you want to look at page 43?
42, please.
42.
Now this section, this is in the section which concerning limitations. I accept that. But the observation that's made on page 42 is nonetheless of interest under the heading test case in the middle of the page, where they say a test case could potentially help to clarify the application of the law on limitation in the motor finance context. We have, however, seen fact patterns regarding disclosure of commission in motor finance transactions vary greatly across firms and over time. So it would be challenging to identify a set of fact patterns for the test case that can be considered representative of most scheme cases. The test case would also take months, if not longer, to resolve, causing potentially extensive delays to the scheme. On balance, having considered consultation feedback on this issue, we consider the delay to consumers receiving redress outweighs any potential benefit which a test case might bring. Now, I just pointed that simply for the observation by the FCA themselves that based upon all the work they've done, that they have seen fact patterns varying greatly across the cases and between firms and indeed over time. And that comes back to this point I made, and you're probably bored of me making it now, is that every case is going to turn on its own particular facts. That's the fundamentals.
It might be pointed out that this is in the singular, what one might envisage is plural.
Well, I would suggest that even plural is problematic against the language used by the FCA, varying greatly across firms and over time. That's the point. The first point I wanted to make on this document. The second is a point that I can't show you the page because it's not in the bundle, but I'm going to, if I may, read it out, and if you'd like a copy, I will arrange for you to have it. And that is that.
We haven't got the complete.
No, you've just got extracts that the claimants chose to put in. It's clear that the FCA were not intending to say anything in their policy statement that was intending to cut across or indeed make any observation about CPR 7.3. And I say that because in Annex 1 to the policy statement, which was labelled the cost-benefit analysis, which, as I say, we don't have in the bundle, they actually refer to this very appeal, the Angel appeal, at paragraph 143 on page 305. I'm just going to read out what it says. It says, claims may also be pursued through group litigation mechanisms. We also recognise that at the time of writing, a single omnibus claim form can be used to bring claims from multiple parties, following the decision in Angel and Black Horse. However, whether the decision in Angel could lead to bulk motor finance claims is uncertain, and the case itself is being appealed. For example, whether it be possible to deal with certain unfair relationship claims in this way would ultimately depend on the facts and the way the case management judge proposes to deal with the claims. So we would expect to say, went out of their way to make it clear that they weren't saying anything at all about the suitability of claims for omnibus or multi-claimant claim forms. On the contrary, they're putting down a reservation. Actually, there might be problems with it. Now, my own friend said yesterday afternoon, and again this morning, that these proceedings compared favourably to Abernethy, because in this case, unlike in Abernethy, the claims have been brought against single defendants. But that, with respect, doesn't meet the fundamental issue that Honourable Judge Kelly identified in Abernethy. And I'd just like to show you one passage on that. That's at Authorities, Volume 4, tab 50, at page 1372.
Thank you. Yeah.
And she says that the determination of whether all claims can be conveniently disposed of in the same proceedings will turn on the particular circumstances of the claims. The only claim before the court is the Abernethy claim. It's not the other A claims or the B claims, nor indeed claims brought by any other law firms. The Abernethy claim has some 3,420 claimants, bringing claims against 8 defendants. The court is faced with assessing the question of convenience based on generic particular claim and the evidence before the court in respect of the GLO application. So in fact, just pausing there, in Abernethy, the judge had even more than the judge had here, because she also had some evidence, but there's been evidence here about the claims being pursued. The difficulty the court faces is that bar the name and address of each claimant and the identity of the defendant, little more is known about each claim. The claimant's legal representatives have not provided the court or the defendants with any analysis of the issues arising in the claims or sampling proposals for test cases. For example, the details of the different PPI products are not known. It's unclear which cases are likely to give rise to compromise agreements arising from the receipt of arrest payments and in what circumstances. It's not known which claims are outside the primary limitation period. The court is facing a cacophony of claims, but no evidence to explain why they could all be conveniently disposed of together. Precisely the same here. And then over the page 158, she says, my conclusion that the multiple claims in the Abernethy claim cannot be conveniently disposed of in the same proceedings should not be interpreted as a conclusion that omnibus claim forms never have a place in pleading litigation. If claimant legal representatives have undertaken a detailed analysis of their claims, it may, she underlines, be possible to group cases with common themes which enable claims to be conveniently disposed of together. For example, it may be possible to identify claims against the same defendant which all give rise to likely arguments of compromise, based on address payments made further to the same standard form correspondence. A decision in test cases on whether the standard form wording gives rise to a compromise.
Well, we've looked at
yes.
this bit before.
And then on she goes. But the same applies here. There's been no analysis of the claims advanced by the claimants, and all we have is the generic particulars framed in the most abstract terms. Now, I want to say just something very briefly about case management appeals. I want to show the Court of May just one authority which we say is particularly pertinent here, and that's in Authorities Volume 1, tab 7, Court of Appeal decision called McIntyre and Phillips at page 83. And if we can go please to page 95. Mr. Justice Wall, sitting in the Court of Appeal, makes some observations at 43 and 44 about case management appeals. And one of the points he brings out in paragraph 44, which we say is particularly apposite here, is the point about judicial continuity, with the specialist judge managing a case, acquiring a knowledge of it and a feel for it, which is unique. And we would say that's particularly pertinent here with His Honour Judge Worster. 5 hearings over the course of 12 months, giving the claimants every opportunity to explain how they said this is going to work. Detailed sampling proposals, exchanges of submissions on that, skeleton arguments. On any view, His Honour Judge Worster had a unique feel for this case.
We have the difficulty, which is we can't just go back to.
I'm going to come on to that. Let me deal with it now, actually, as my lord has raised it. Now, I just want to make this point, just so the court is aware of it. I'm not suggesting this has a sort of legal punchline. I just want the court to be aware of this point, which I think we've deduced anyway from the skeleton arguments. In fact, it's entirely fortuitous that the claimants had the ability before Mr. Justice Ritchie to say that His Honour Judge Worster had made an error of law. It's entirely fortuitous. But what in fact had happened is he had delivered his judgment in draft prior to the decision in Abbott being handed down. And in that draft, he concluded the claims did not satisfy CPR 7.3. So he reached the same conclusion as he ultimately concluded. Abbott was then handed down while the judgment was in draft. The parties made further submissions, and the judge then revised his draft judgment to make it more Abbott-centric. But he reached the same conclusions. His conclusions did not change.
Yeah.
But it was only because he made his judgment Abbott-centric. It then allowed the claimants to say it should be set aside following Abbott having been not followed by the Court of Appeal in Morris and Williams. So we say that it is entirely fortuitous that those circumstances arose. As I say, I can't give you a legal punchline to that, but it's an important part of the.
There isn't a punchline.
It's an important part of the story, as it were. And my own friend.
Well, we're conscious of that, but I mean, we are acutely conscious of that fact. But it does raise the question: to what extent, if at all, we can now go back and rely on anything that Judge Worster did or said?
Well,
certainly leave the draft judgment out of it.
Yes, I haven't based any of my submission on the draft judgment. I accept that's not something that it'd be appropriate to do, beyond identifying the conclusion was the same. But my learned friend, I think, at one point yesterday suggested that if you were minded to set aside Mr. Justice Ritchie's order, then it may be this court would need to remit it back to Birmingham and we basically start all over again. And that, with respect, is plainly ludicrous. We say that this court would be perfectly entitled, and we indeed would say should, in those circumstances, make an order in equivalent terms to the order made by His Honour Judge Worster. And there's nothing procedurally wrong about that.
So we overturn Mr. Justice Ritchie, and if we do, you encourage us to give case management directions, which happen to coincide with those of Judge Worster.
Well, let me show you his order, so I'm clear about that. His Honour Judge Worcester's order is at 4 bundle 3, tab 71, at page 877. We can I think skip over. I'm on page 879. We can skip over paragraph 1 because that was simply staying paragraph 2 until the question of appeal had been resolved. And then paragraph 2 is his operative ruling that, and indeed my learned friend I think alluded to it this afternoon, that every claim bar, as it were, the lead claim on each claim form be reissued by way of a claim. All those claimants get the benefit of the deemed date of issue that they would have got on the omnibus claim form, and if they don't do that by what's called the long stop date, the claim is then struck out. So I would encourage, invite the court in the circumstances postulated to remake paragraph 2, and then I think the only other direction I would say in those circumstances is required is paragraph 11, i.e. remitting the case then back to Birmingham for the judge to case manage.
I think I checked overnight because there was some askance looks. I think he retired in September of last year.
Right. Well,
so somebody else will
take it up. So I would say paragraph 2 and 11. That's all this court need do. There's no jurisdictional problem in doing that. You don't need to get into, and indeed, I think as my Lord Justice Coulson intimated earlier, you might feel uncomfortable in making your own case management directions. I don't think you need to do that. I think you make paragraph 2, you disaggregate, and you send it back.
Well, speaking in terms of myself, if we get to the stage where we have power, technically have power to do something, the instinct to do anything to get this case moving is quite strong. Whether we do it by your paragraphs 2 or the Worster paragraphs 2 and 11. I think I speak for all three of us. We have a strong sense, for reasons which you've been battering away at, that something needs to be done if we can usefully do it.
Well,
conveniently do it, I should say.
Well, there's no reason at all why a CMC could not come on in Birmingham in relatively short order after the judgment of this court's delivered. It doesn't need to be...
I have in a previous case had a direction where we directed there should be 2 CMCs, that the first CMC should be fixed very shortly, within sort of fortnight or 2, to determine what the CMC is. Well, so you don't have the palaver of everyone turning up and saying, what are we talking about?
No, well, I can see the sense in that, my lord. But you know, we would say the appropriate course is to get Birmingham moving again. You know, I understand, as you say, that His Honour Judge Worster might not still be in the chair, but that court has been very effective at managing this case over the period. And what has bogged this case down is nothing to do with my clients. It's the way in which the claimants first started this case out, i.e. warehousing claims, putting them on an omnibus claim form.
You do yourself an injustice when you say it's nothing to do with your clients.
So that's what I was going to say about the question of jurisdiction.
Well, I hesitate to interrupt my own friend. It's very nice to listen to him, but I think it's about 7 minutes past his half
Yes,
hour.
I did wonder. Thank you very much for that. I did wonder about that.
I don't want to be super strict.
Well, I think it's only fair, Mr. Cavanagh, having been extremely efficient in the making of his submissions, that I don't think we could allow you to, as it were, take up the entirety of the slack. So I think there's one point that you said you were going to come to, which I don't think you have yet, which I, for one, would be pleased to hear, and that concerns the question of the brokerage agreements.
Well, Lord, I thought I had dealt with that, but perhaps inadequately.
Well, I think the point is made in response to the pleading out some claims point. Well, we can't until we see the brokerage agreements, because we don't know what the undisclosed commission was.
But that, with respect, is a red herring, because they've already have pleaded out that arrangement existed, and there's a statement of truth to that effect, and they say, as a result of that and various other things, the relationship was unfair. Obviously, the next step then, if they pleaded that out on an individual basis, would be my client would then put in an individual defence explaining why for that claimant actually the arrangement was X or Y, or why there were particular factors that meant it wasn't unfair, and then there'd be a reply. So
is that realistic in circumstances where the unfairness, a factor in the unfairness may be the amount of the undisclosed commission, which they won't know?
But that will come out in the ordinary way through the pleading process, and then, as my own friend says, in advance of the small claims hearing. There's no. It
will come out, but that's on the basis that they plead 5,000 claims. If there's some way of narrowing down the number that are pleaded out, then that becomes an issue, doesn't it?
Well, my lord, we would say that, if I may respectfully say so, that the very question, the very fact my lord is asking that question, demonstrates that it's not convenient for these claims to be on a single claim form. I mean, that is the antithesis of convenience. If they're saying, well, we can't plead this all out, it's just too big a job, it just demonstrates we're outside 7.3. Once you're outside 7.3, you're then, by definition, into a series of separate claims. And the question then becomes, as I've always accepted in exchange with my Lord, or Justice Stuart-Smith, yes, it's open to the judge in Birmingham to manage that lot as he or she wishes, even though they're on individual claim forms. It might be that some will be pushed onto the fast track, and they can work their way up through the appellate courts if there are points of principle. But you don't need the commission arrangements to plead out what they say is the unfairness, and indeed they've pleaded it.
There's no use crying about spilt milk, but just imagine, if we weren't talking about 5,000, we were just talking about 5, or even 1 case. If there had been an application for pre-action disclosure of the brokerage agreement, what would the answer have been?
I find it difficult to answer that, my lord. I mean, I agree there wouldn't be a proportionality argument there. It might be difficult to resist that, but we are talking about 5,000. That's the important point. And my lord, if I may say respectfully say so, in exchange with Mr. Cavender, you seem to think that we can just go off our computers and
we've got the Leicester Aldridge evidence.
Pull 5,000. I mean, it's a vast exercise where that evidence shows that these things aren't archived in the way that you might imagine. And it's no answer to say, oh, they're a big company, let's get on with it. And if they want more time, they can come back for more time. But that's just no answer. So we respectfully say that as soon as you're asking these sorts of questions, which my lord is asking, you are by definition recognising this case is not 7.3, because it's just not convenient for it to be run in a conventional way, i.e. with a set of particulars pleading out the relevant facts.
But you accept that case management may be relevant going forward.
I know we had this debate yesterday. I say that, and I'm not sure actually there's necessarily much between us when it comes to it. Mr. Justice Andrew Baker and Lord Justice Dingham said, just because something can be case managed together doesn't mean it's suitable for 7.3. And that's my fundamental point. Just because you conclude, actually, yeah, it'd be sensible for these cases to be managed together, you're therefore into 7.3. That's my only point.
Well, I get that. But that is a slightly different nuance, at any event, to the answer given by the defendant's then counsel to Mr. Justice Ritchie.
Well,
in answer to the Armageddon submission, there was effectively an Armageddon submission in response.
I wasn't at that hearing.
I understand that, but that is one of the that is a relevant factor for us to consider, because obviously Mr. Justice Ritchie had to deal with the arguments as they were put before him, and the response to the Armageddon was effectively, well, it's the four winds.
But the problem with that, my lord, is that Mr. Justice Ritchie, in his judgment, when he identified Route 1, Route 2, he identified that if you had individual claims, you could still have common case management. That's at the beginning of his judgment. When he comes to the end of the judgment and he's working out which way to go, he totally loses sight of that. And he just thinks his options are actually either 5,000 claims or omnibus. He doesn't actually himself turn his mind to the alternative routes he'd posited at the outset. And just on the point that Mr. Cavender made about you can't case manage small claims, I simply don't understand that submission. CPR 27.2 identifies those parts of the CPR that don't apply to small claims, and one of the bits that is not excluded is CPR Part 3, i.e. the section on case management. Now, I mean, there's a lot more I could say, but I won't, conscious that I'm trespassing on the court's time. Can I just make 3 incredibly short points, by which I mean 60 seconds?
3 60-second points.
No, I'll do it all in 60
seconds. Oh, okay, fine. Go on then.
Point 1, my Lord Justice Coulson asked, are you allowed to take into account convenience to the court? Answer, yes. Mr. Justice Garnham had said so in Adams, paragraph 18. That's volume 4, tab 45, page 1115.
But not the fee.
That's my point 2. Some judges have expressed concern about fees in the context of multi-party claim forms. I'm just going to give you one example. His Honour Judge Hodge KC in a case called Nipros. That's volume 4, tab 43, page 1060, paragraph 6. Point 3, before I sit down, is my Lord thanked Mr. Butters for having stayed up all night producing his note. We obviously saw that for the first time this morning, along with his 195-page bundle. I would just like the opportunity, if I may, to be granted the chance to put in, if I think necessary, across the defendant group, a short note insofar as we think there are other points to be made about that.
What would the starting point be that if there's any error or addition that can conveniently be put into Mr. Butters' note, then that's the place for them. If by some extraordinary chance he's missed out something, and then if you've got a note of substantive things.
I mean, the only thing I would say
it's a chronology.
That note has got a very, if I may say so, claimant-centric spin to it, and I understand why. It's
only because he stayed up all night already.
It's an advocacy piece, and therefore I'm slightly nervous about saying we will just put stuff in his note. I would just like the chance to have 2 or 3 pages, if we need it, to put something in just to reset the balance.
Well, if it is, my view would be yes, provided it's in convenient form, and if it is a chronology, changes to a chronology or additions to a chronology, then that can be most conveniently done by amending in red the chronology. If there's a specific point, yes, provided it doesn't exceed 3 pages.
Thank you, Lord. As I say, there may not be a note. I just don't know what's out there, and indeed I can't speak for all the defendants. They might have other points, but between us we will produce.
Yeah, and can we have that by in 24 hours, 4 p.m. tomorrow? Given that Mr. Butters was up all night, I think we should acknowledge that the response, we're giving you longer than he put it together. Okay. Also, I mean, of course, nobody cares about this, but the court would be endeavouring to collate some of these submissions into producing a first go at some draft judgments, and those judgments are always better the sooner they're done after the hearing.
Yeah.
So I shall be spending all of tomorrow considering this case, so that if there are points, I don't think it's unreasonable to ask that they be done within 24 hours.
Understood, my Lord, and I will ask my junior to stay up all night tonight to produce his.
Defendant-centric approach, we say best endeavours.
Not best endeavours, 4 p.m. tomorrow.
Well, can I say if there's additions to the chronology, so be it. If there is a new point, I'm not quite sure what new point there might be.
Well, I don't think Mr. Goodall necessarily knows if there is a new point, so we'll just have to see.
But if there were, I reserve the right, if necessary, to reply on the new point.
If there is a new point, you can notify us. We'll consider if it is a new point. If it is, we'll let you respond. Yes. Just give me a minute. Right. Okay.
I've been accused of being centric.
Thank you very much to all of you and all of you sitting behind you. As advertised in the last thing I said, we will not be now embarking on an extempore judgment. We will reserve our judgments and you will get them in due course. As you know, when we have concluded the draft judgments, you will get them as drafts. They're subject to the embargo. The embargo means that the drafts can only be circulated to those on the list that has been notified to my clerk. So I assume that's happened, but if it hasn't, then the parties need to identify the people who get the draft. It is a draft, so it cannot therefore be referred to in any circumstances until it's been finalised. The draft is provided so that you can correct our typos and our grammar, but it is not an opportunity to re-argue the case. Once you've seen the draft, we would hope that you would be able to agree an order consequential upon the draft. If you can't, then the best thing to do is to provide a draft order with the disputed bits in red so we can see what the differences are, and provide at the same time very short submissions on the points that are between you. And then we will hand down the judgment at the same time as we hope making the final order. And of course, there's no need to attend for the hand down. Yes, well, I think that's everything. As I say, thank you all very much. I should also add that whenever I sit on a procedural appeal, I find procedural appeals very interesting. People who don't often sit on procedural appeals think, oh God, it's a procedural appeal. At the end, they always say, that was really interesting. And they say that with surprise, and I say, you shouldn't be surprised. Procedural appeals are always interesting.